everyone. Esteemed Granville, it is truly an honor to stand before you as we come together to delve into the profound theme revisiting the experiences of emergency, the counter Mediterranean conundrum, and the spirit of liberty. Before we begin our program, let us take this solemn moment to reflect on the legacy that Dr. Austin and his contributions as they continue to inspire the constitutional scholarship. I would like to extend a heartfelt invitation to all present on the stage to join us in paying homage to Dr. Austin through the tradition of floral tribute and lighting of the lamp. Now, as we embark on this intellectual journey, it is my honor to invite Professor Dr. C. Raj Kumar, the founding Vice Chancellor of OP Jindal Global University, to deliver the welcome address, setting our stage for the discourse ahead.
Thank you very much. Very good morning to all of you. My sincere apologies for the slight delay in starting this program, although Parag did come on time, but I wanted to show him a bit of the campus. But I'll cut short some of my reflections so that we'll have enough time for other speakers. Today we are indeed here to celebrate the life and contribution of an extraordinary man by name Dr. Granville Austin. Dr. Granville Austin, we talk a lot about it, and I know that my colleague Dean Sudarshan is going to speak a bit about it. But he is the author of two fantastic books that everybody who is not just involved and interested in the field of law, but also interested in the historical evolution of India ought to be reading. The first book is known as The Indian Constitution, the Cornerstone of the Nation, and the other is Working a Democratic Constitution, the Indian Experience, both published by Oxford University Press. I had the privilege to meet and spend time with Dr. Granville Austin as a young student at Harvard Law School in the year 1999-2000, when I invited him as a part of a conference that we're hosting in April 2000 as on human rights and Indian judiciary's constitutional jurisprudence. And Dr. Austin was there. As a student in Delhi University way back in 94-97, at that time, Granville Austin would come very often, at least once a year, to India and would stay at India International Center. And I had the privilege to interact with him briefly. But over the years, those interactions, especially when I was at the US, became even more stronger. And his humility, his gracefulness, his self-effacing nature, his intellectual integrity, and his deep admiration for India, for all its complexities and contradictions, made him very special. And that is why we are very fortunate here at OP Jindal Global University to be able to host the Granville Austin Memorial Lecture. I'm also very deeply privileged to welcome an extraordinary man, a jurist himself, Mr. Parag Tripathi, a senior advocate in the Supreme Court of India. Mr. Tripathi belongs to that generation of rare advocates in India whose intellectual rigorousness as an academic, as a scholar, as a thoughtful leader, has enabled him to contribute significantly to the legal profession. Parag Tripathi is a graduate of the Faculty of Law, Campus Law Center at the University of Delhi, and also a very proud graduate of the Harvard Law School, which had in his class two other individuals. One person is now the Chief Justice of India, Honorable Dr. Justice D.Y. Chandrachud, and the other is Professor Hilary Charlesworth, who's judge of the International Court of Justice at The Hague. So, two distinguished judges and one distinguished jurist were part of that class at Harvard Law School. Mr. Parag Tripathi is no stranger to our university. He was one of the few and probably the first lawyer who made a commitment to teach and to pursue academic interests in this university. He and his distinguished wife, Neelima Tripathi, both have for many years occasionally taught a full semester course at Granville Global Law School. They have stayed on campus and they have seen this institution evolve in the last 15 years. And I owe a lot to Parag, not only for his commitment and dedication to the legal profession, but also to be my mentor for many years. He believed in the idea of this university long before the world believed in. He supported us all through this journey and continues to be a great mentor for me personally. So thank you so much, Parag, for your presence and participation. For those of you who may not be aware of Parag Tripathi as a lawyer, all I can say is that Mark Galanter wrote an article about the state of Indian legal profession. And he talks about litigators and litigating lawyers. And he says that there is this institution of the senior advocate, which is a designated senior advocate of the Supreme Court, where people have attained the highest levels of standards in the legal profession. And then Mark says that there are some people among the senior advocates who Mark Galanter calls as the grand advocate. And this is the terminology that Mark uses. And the grand advocate is a person who not only has attained the highest levels of achievement in the legal profession, but is also contributing significantly to the development of law and jurisprudence. Mr. Parag Tripathi is one such grand advocate that Mark Galanter spoke about, and we are very, very fortunate that he has accepted our invitation to be here and to deliver the Granville Austin Memorial Lecture. Thank you so much, and I sincerely hope we will have a wonderful time hearing him and also the discussions we will have with our students and faculty. Thank you.
Professor Raj. Following this, we're delighted to hear from Professor Dr. Khushbu Chauhan, Associate Professor and Associate Dean at Jindal Global Law School, who will provide us with her introductory remarks, guiding our understanding of the intricate themes that lie ahead in today's discussion.
Good morning, everyone. Welcome to the Dr. Granville Austin Memorial Lecture, an occasion commemorating the legacy of a scholar whose work continues to illuminate the intricate dynamics of constitutionalism in India. Today, we delve into a theme of profound significance. In the annals of Indian jurisprudence, few episodes have tested the resilience of democratic institutions as profoundly as the emergency era. Dr. Austin's meticulous scholarship shed light on this critical period, offering insights into the interplay between power, law, and the pursuit of constitutional ideals. Undoubtedly, it is our pleasure to have Mr. Parag Tripathi, Senior Advocate at the Supreme Court of India and the former Additional Solicitor General of India, as the distinguished speaker, offering his insights, perspectives, and scholarly reflections on this dynamic theme. As we gather here today, we embark on a journey to revisit this pivotal juncture in India's legal and political history. We hope to explore various emergency experiences along with the role of the Indian Supreme Court, the guardian of the Constitution, during a time when democratic principles faced unprecedented challenges. Through a nuanced examination of the spirit of liberty, judicial decisions, institutional responses, and the broader socio-political context, we seek to unravel the complexities faced during the engagement with constitutionalism amidst the chaos of emergency. Indeed, the legacy of the emergency reverberates through the corridors of Indian jurisprudence, prompting us to reflect on enduring questions of individual rights, state power, and the judiciary's role in upholding the constitutional order. As we commence this intellectual exploration, let us draw inspiration from Dr. Granville Austin's commitment to understanding the intricacies of Indian democracy and his unwavering belief in the transformative potential of constitutional. Together, let us honor his memory by engaging in a thoughtful dialogue that not only illuminates the past, but also informs our collective aspirations for a more just, stable, and constitutional. Thank you.
We are privileged to have with us the esteemed Dean of Jindal School of Government and Public Policy, Professor R. Sudarshan, who will now share with us his reflections on the contributions of Dr. Granville Austin, shedding light on the indelible mark left by this visionary scholar.
Thank you very much. Firstly, I must compliment the Vice Chancellor. Is in memory of contribution during have to be. I remember a lecture in commemoration of P.K. Tripathi, giant Delhi law faculty, played a significant part in legal scholarship shaping the thinking of judges and outcome. And was a giant, and there's not a single jurisprudence professor anywhere around the world not know and have read works of P.K. Tripathi. It was well known, and I'm grateful that I have lectures in his memory. Now, Granville Austin, known as Red Austin, different category altogether. He went to Oxford University to do a DPhil, St. Anthony's, and that was the time when the formulated. So he thought it's a good idea to write a PhD framing of India's constitution. And this is like anybody choosing a PhD topic. What is viable? No one else has worked on this, so this will qualify for doctorate because you have to make an original contribution. And for that reason, he picked it, not because, like many others who and fell in love with the country and so on. And none of that. Did this, but he had the enterprising ability to write to the Prime Minister of India, saying that he would like access to the papers of the people who were participating in the Constituent Assembly. And the Prime Minister, being the kind of person he was, thought he was a young person from Oxford University. They'd still not set up, of course, the, what is now the Nehru Memorial Museum Library. There were no archives, but the National Archives had the papers of Rajendra Prasad, the President of the Assembly, and others. So he asked staff to help this young man with access to papers. And he got it and was able to write an account which is very accessible. It's, there are 17 volumes by Shiva Rao, The Framing of India's Constitution. Sheer size of that is forbidding. I mean, they're not just the Constituent Assembly debates, they have been separately published. But Shiva Rao's work is a commentary on it. But that's not so accessible. But Granville Austin was able to write in a very simple and elegant way this account of the framing of India's constitution. Because it's so accessible, it began to be quoted. And you have many references whenever there is a reference to what happened in the Constituent Assembly, the Supreme Court, they would refer to what Austin said in his book. And so when at one point I came to work in the Ford Foundation, and I've always wondered, well, what happened to Granville Austin, published in 1966, this book. After that, there's absolutely no reference. He's done nothing academic at all. But then, he just disappeared. And so it was a bit of a detective role that I took on, trying to figure out where is this man. And so I was making inquiries, but not really getting anywhere until I was attending a conference in Washington, D.C., and it was at the Carnegie Government building, and there was some kind of a cocktail party. And I was saying to somebody that, I'm looking for a person called Granville Austin who wrote this book. And so somebody overheard me, said, "Oh, you mean Red Austin?" Now, I didn't know he was known as Red Austin. He had red before his hair turned gray, red. And that's why he was known as Red Austin. As I said, yeah, I didn't know he was Red Austin. He said, "Oh, he lives on 11th Street at 286 or something." I just walked out of the reception, grabbed a taxi, and landed up at the address that was given to me, knocked on the door, and his wife, Nancy, she opened the door, and I said, "I'm looking for Dr. Granville Austin. Come on in." And there he was, sitting there in his house in a garden. He'd retired. And so I then told him, "Look, I've been looking for you for years and years." And so we had a long discussion. And I said to him, "You were a fellow at St. Anthony's College when you produced your first book. I'm now a program officer in the Ford Foundation." And the Ford Foundation, being the kind of organization, it trusted its program officers to make judgments about what to fund. And that's a special feature. I don't know if it's still the case with the Ford Foundation. I said to him, "I can make a grant, not to you individually, because for some other reasons I had stopped making grants because it compromised the individuals who got the grant. One of them was Professor Urmila Fadnis. Then there's an IB file that offers somebody an individual grant. And I felt that they are innocent. I mean, they don't know an IB file gets created. So I stopped the practice of making individual grants. So I said to Red Austin, "We'll make a grant to St. Anthony's College, out of which they will offer you another fellowship. And please write a book on the working of India's constitution." And he retired, and he said, "Yes, I'll do that." And he went off and then joined St. Anthony's. It took a longer time. The grant was for 3 years. Then he came and stayed in Dorbag and with his wife, Nancy. Now, Granville Austin, when his first book appeared, there was a review of it by Professor Upendra Bakshi. The review was called "The Little Done, the Vast Undone." And Upendra Bakshi, of course, is writing from a scholarly perspective. And Granville Austin's account is kind of, narrative, right? Where's the theory, right? Missing. So I asked Red Austin, this was the criticism of the first book, that you didn't have a jurisprudential theory. He said, "I'm not a lawyer, I'm not a jurisprudence." He said, "I'm a digger." That's the word he used. I dig for information. I try to put that information that I garner in a coherent way so that it's easy on the reader. And his whole strategy was to go and talk to every person who was involved in the activity that he was writing about. Everyone alive when the Indian Constitution had been framed before 1966, he interviewed. Likewise, when he came to work on the second book, he interviewed everyone who had anything to do with it. KVK Sundaram, first law secretary, subsequent law secretaries, lawyers, politicians. He interviewed every one of them up and down the country. And so he admittedly said, "I'm going to tell a narrative, a story." And the story is about how in the working of India's constitution, we went through all of these amendments, and so on. And so Upen wrote another uncharitable review of this book, which he called "The Gospel According to St. Austin." Now, the point is we have to appreciate the contribution of someone whose writing is accessible to people who are not familiar with legalese and legal writing, or who are not writing in the language which is used for articles that are published in Scopus listed journals. he is writing in a way that's accessible to the layperson, and the high quality of it is because it's based on elaborate notes that he took of conversations with people who played a role in what happened. You meet people and find out from them why such and such a thing was done. So it's a very gripping narrative, actually. Second volume on all of the changes up to 1985, from the time the Constitution was. And so I'd second the Vice Chancellor's advice to those who have not read the book to read it, because it's a gold mine of information about the changes that have happened, Constitution, the actors who played part, wonderful discussion on what was meant by the idea of a committed judiciary, what Kumaramangalam did, how did Krishna Iyer come to become a judge of the Supreme Court. You have all of those narratives in that story. And I'm very happy to have known him. I worked intensively with him on that book, incidentally. And that's one of the other things that program officers of the Ford Foundation in those days do, not breathe down the neck of a grantee, try and help the grantee with the work that they're meant to do with the grant. And I'm very grateful that I had the luck and privilege to do that.
Thank you, Dean Sudarshan. And now, without further ado, it is with great pleasure that I extend a warm welcome to our distinguished guest of honor, Mr. Parag Tripathi. Mr. Tripathi's presence here today is a testament to his eminence in the legal sphere, and we eagerly anticipate your lecture, sir.
Distinguished, certainly dynamic Vice Chancellor for a very long time, my good friend. Ladies and gentlemen, I would begin by recalling what Upen Bakshi, my good friend, talked about him. Wasn't as charitable perhaps as he should have been on Dr. Austin's contribution. Published an article, The Passing Away of My Father, in the journal section of 2001 FCC, where he highlighted as one of the contributions of my father, installing a model of constitutional scholarship of judging the judges. That is a very difficult doing, because it's not easy. It's very easy to say that a judgment says X, Y, Z, and says A, B, C, I agree with this, that. It is when you judge by constitutional scholarship a contribution of a court, that is where you really further, you push the envelope, saying goes. And of course, then Professor Bakshi rightly laments the fact that the provision for having our distinguished academics have a seat in the Constitution, in the Supreme Court, has never been followed. That's a great loss, because he says it has denied us our equivalent of Professor Justice Felix Frankfurt. I can at least think of 5 distinguished people that and sat in the Supreme Court, including Professor P. Singh, who is associated with law school, Professor Bakshi, and some others who unfortunately not with us in this world now. But that's another story. We'll deal with it some other time. I carry a heavy burden of trying to fulfill the caveat Upen Bakshi put in that article, saying that as a young lawyer, I should not be carried away by the runaway escalator of appellate lawyers' prosperity track. So I'm trying to do my little bit. I have not reached the prosperity track, but I'm not being carried away by it either. Now, coming to Dr. Granville Austin, we have already heard about him, and he exemplifies the principle that you don't need formal training in law to contribute to jurisprudential thinking and constitutional. That is known as a fresh approach. As was pointed out, he himself called himself a digger of facts. So therefore, this is something which you have to always remember, that law is not merely reading and doing formal education, but the wider education of life itself with the attendant rules. After all, we all know the jurisprudential theory of the king having no clothes. That can only be said by a child, by saying that, look, this theory, this belief has no clothes. For that, you have to have that thinking and analytic mind to go about it. We have, of course, dealt with the two outstanding contributions of Dr. Austin to Indian Constitution. I was going through a nice article of Gautam Bhatia where he dealt with the Sabrimala case, and he reiterated what Austin had said, and that was, he said that Austin in turn quoted an American jurisprudential scholar to say that to be able to find out what is the scope and ambit of fundamental rights, you must first examine what are the fundamental wrongs that are sought to be addressed by. So in the US, it would be partly racial discrimination. In India, it would be untouchability, equality, having your own setup. But you can never divorce the two. You must know what's the constitutional wrong, and then you proceed and decide what is the scope and ambit. One of the important inputs inside the scope and ambit of. I say this because fundamental rights and its enforcement is central to my little presentation here. Experience of emergency, of course, now almost 5 decades old, but it's still relevant. Concept of counter-majoritarianism, which is always a concept which has continued with judicial review. What is the role of constitutional court judges? Why and how they are anti or counter-majoritarianism? Does that concept really work now? Because there's a lot of scholarship after 1990s which says that counter-majoritarianism in the highest courts, particularly in the context of US, is having a weaker and weaker impulse. That's the other aspect. And of course, the spirit of liberty, which is why we have a constitution. In the famous dissent in the civil rights case, in 1875, after the war of the American Civil War, they came up with the Civil Rights Act in 1875 to give greater rights as the federal government to the marginalized people there, basically the black people. So they extended the purview to private spaces like transport, like restaurants, which are owned and operated by private people, not merely strict state action. So this goes to the Supreme Court in 1883 there. And the majority refuses to be swayed by any counter-majoritarian impulse, and they uphold it. Harlan dissents famously, and he says that a law has not only an external sense, the words of law, but it also has an internal sense, that is the reason of law. That is the soul. And therefore, he said that the act has to be upheld. It was the reverse of counter-majoritarianism. He took a principled stand to uphold the act. The majority struck it down, exercising, if you must call it counter-majoritarianism. In a sense, if you look at it, they were really following the view of a large section of American society, which really believed then in 1883 that blacks don't serve these. These are very emotional issues. That is how the thinking was. A large part of the Americans then thought that, sorry, these rights are only meant for whites and white immigrants, and not even be for the local Native Americans. So you had the acts were brought in under their 13th Amendment, which is like our Article 17. There it is racial discrimination. Here it is, of course, untouchability. And the 14th Amendment, which is like Article 14, we all know. Now, what is counter-majoritarian or anti-majoritarian? Well, in a democracy, majority view or the society speaks from the law-making chamber. In India, it's the parliament. When a parliament makes a law, obviously it is understood that that law reflects the will of majority. When that law comes up in a challenge before a constitutional court, yeah, it would be High Court or the Supreme. Then, if the law is upheld, well and good. But if the law is struck down, what the court is really doing is running counter to the majoritarian impulse, the majoritarian desire, which was that the law has been passed has to be. So this part of judicial review, which is our Article 13, of course, America, it took Marbury versus Madison to impose it. It was exercised much later. This is counter-majoritarian. And this has been looked at with suspicion. So you had the Harvard professor James Bradley Thayer, 1893, pointing out that this is a problem with judicial adjudication in his famous article on origin and scope of American doctrine of constitutional law. Alexander Bickel was from Yale, picked it up. And his book, of course, of the least dangerous branch, Supreme Court and the Bar of Politics, is still one of the classic works. I take a part of my title of my presentation from Justice Learned Hand's article or speech called Spirit of Liberty. Remember, that was given in 1944 when the war was still not over, on the I Am an American Day. As you know, in America, every thing and event there is a day, Father's Day, Mother's Day, etc. day, whatever. This was I Am an American Day. And he comes up with two very interesting contributions. And he points out that when you look at constitutions and laws, remember that his view is that I often wonder whether we do not rest our hopes too much upon constitutions, on laws. And these are, he called them, false hopes. Believe me, these are false. Liberty lies in the hearts of men and women. When it dies, no constitutional law or court can do much to help. While it lies there, it needs no constitution, no law, no court to save it. Please don't take it literally, because that will mean putting a lock on the constitutional courts, because you don't need them either way. But remember, thinking, and jurisprudential thinking is no exception, has an element of the blind man and the elephant. Every great thinker picks up a point and illuminates it. That doesn't make it the entire universe, but it's a very important aspect. This is an important aspect. Then mere law will not give you your spirit of liberty enshrined and protected. It will also have to be in the hearts of people. And we saw that during emergency, when the people of India threw out a government whom they thought was not performing as per the constitutional mandate for so many reasons. And remember, when emergency was first imposed, there was a huge swell of support. The buses started running on time, people used to report to offices on time. But then as it went on and the manner in which it was run got this reaction, based on the spirit of liberty which was there in the hearts and souls of Indians. And then, what is this spirit of liberty? It's fundamental to all this. And here, Leonard Hand says, I can't define it. But he says, and this is a very telling statement which we should all remember with all our views. The spirit of liberty is a spirit which is not too sure that it is. That's the point. Because if it is too sure that this is right and this is the right, then it slips into a religious dogma. Liberty is different from. That's the beauty of liberty. In liberty, I have a very clear view. I'm not too sure it is right. It may not be. I think it is right. That I think it is right is what a society should strive for. If you strive for that, so many of your conflicts resolve. Because then you respect the other man's right. But all right, he thinks that is right. I think was wrong. That's it. And then Leonard Hand says, the spirit of liberty is the spirit which seeks to understand the mind of other men and women. It is not merely that I have figured it out and this is E is equal to MC square. I also want to figure out, how do you look at it? I'm not going to, as Gandhi said, that in my house all doors and windows are open for all thoughts to come through. They'll come through, but none of them will sweep me off my feet. I'll remain firm. I will be in my house, but I want all thoughts to come through. That is the spirit of liberty. Sometimes we as a nation stray away from it, and we should remember to come back. Yes, this is my belief, but I'm not too sure that this is the only correct belief. That doubt is so important. Now, I've told you about the classic view of the anti-majoritarian or counter-majoritarian view of course. So this was the only basic theory. You know Hegel's doctrine of thesis, antithesis, synthesis. So the basic thesis for a fairly long time, from 1893 to almost a century. Then in 1990s, there was a second limb to this theory. And that starts from people like Barry Friedman and Michael Dorf. And what they say is that, wait a minute, is this counter-majoritarianism really such a conundrum? Is it really such a big deal? And then they say that, look, if you look at the experience in courts, you will find that judges seldom deviate from the median of public opinion. So it is not that judges sit down and say, okay, 19. That's not how it works. The judges, of course, whichever way you say, they have a cloistered life, whether ivory towers or not. But they are citizens of the country. They know what's happening. So, and I'll show you from a few examples how this awareness of the median of public opinion has always been the major inarticulate premise, to use another famous concept, in the functioning of judges. They're always on the, it's the, you've seen that old serial, it's the betal on their back. How will it be taken? How will it be perceived? Am I going too far ahead? Are we going too far ahead? Is it an idea the time of which has not come, in which case it won't be accepted? Then maybe it's not such a great idea to go about it. Now, so I would add only one thing, that it is not merely the median of public opinion, but median of, if in my view, politically relevant public opinion. Why do I use the word politically relevant public opinion? Judges aren't supposed to be interested in politics. They're not. But politically relevant public opinion comes in because when you have a public opinion strongly expressed by the legislature, and when does that happen? When you have a single party rule with a powerful leader. You had that in Indira Gandhi's time. You didn't have it during the coalition. Because they go all here, there, everywhere. You saw that in one of the Congress regimes, the question was about the nuclear deal. So the coalition partners had this view, that view. There wasn't that strong, clear message coming from the parliament or the legislative chamber that this is the law and this is what the people want because we represent the people. Therefore, I say politically relevant opinion. And Barry Friedman, who's actually a NYU, he teaches at NYU and also is a litigator, comes up with a very interesting point. And the point is that he says that when you exceed or go beyond this median, then you will be yanked back. How are you yanked back? So he says you're yanked back either by constitutional amendments, which you let pass, knowing that, or legislative enactments which you let pass, knowing that they are contrary to what you have said earlier, and there are lovely theories as to why it is done. So the basis of the judgment is gone. We all know that, right? The second is there's a change of judicial personnel. And the third is, of course, a brand new, spanking new jurisprudential doctrine. Of course, you know, not that Pakistan ever was a democracy. Wasn't, according to me, except in the initial years when Jinnah was there. In Pakistan, when they wanted to hang Bhutto before the Supreme Court, they brought about a new act which said that the Islamic oath has to be taken by the judges. It's called Haraf Uthana, oath. And that oath, like supposing we are 6 of us judges, it's only given to 3 of us. The other 3 are not given a copy of the oath. They can't take the oath. Judges, very simple. So changing the judicial personnel, of course, in a democracy, it is not done like this, but I'm giving you a glaring example. So naturally, when the judges were there, they said, yeah, hang him, even though there was a dissent. So now let's see how this works out in a true democracy like India. Look at Golaknath. So Golaknath was 11 judges, 67 Supreme Court. The question was whether a constitutional amendment can be tested on the touchstone of Article 15. I just take a, can I have mine? So Golaknath was 11 judges, 6-5. That's as thin a majority you can have. And they applied the principle that, look, a constitutional amendment can also be tested against the existing fundamental. So if a constitutional amendment violates Article 14 or 19, that constitutional amendment is bad. In other words, there is no real distinction between a constitutional amendment and a law simpliciter. Now that's not jurisprudentially very satisfying because constitution is the grand norm. If you look at the Kelsen doctrine, right there, laws take their sustenance from the grand norm, whether it is existing law and treated as if it belongs to one of the lists or a new law. You cannot really treat a law and an amendment at par. That was incidentally one of the critiques which my father gave in the Triambak Telang lectures. Then you come to Keshwanand Bhat. Now this is 13 judges. 1, there is a change in the judicial personnel. Subba Rao, Hidayatullah, Vanchu, Shah, Justice. They were all in the majority of 6. The Congress party was very hopeful of setting aside Golaknath. They got their wish, but not the whole wish. Because Golaknath went, basic structure came in. And incidentally, you all believe that basic structure is a creation of Keshwanand Bharti. It's not. Basic structure was argued by M.K. Nambia, one of our first great lawyers, constitutional lawyers, who has an equally great son, the K.K. Venugopal, last Attorney General of India, in whose chambers I have devilled for 7 years. And he still has Mr. Nambia's meticulous handwritten notes on what he would argue. Nambia had argued basic structure. Subbarao said it's a very interesting point, but it did not detain us, because in any case, we are going to say that Article 13 is a complete answer. Before coming to Keshwanand and saying how counter majoritarianism comes in, because it was a little extraordinary that a constitutional amendment is being challenged and can be challenged as violative of constitution before a judicial forum. No other country, certainly not England, certainly not US, has ever gone that far. That can I, if there is a constitutional amendment, because there's always a procedure for it, can it be struck down? So when Golaknath, the overruling of Golaknath came up in Keshwanand Bharti, that is why it was a 13-judge bench, Palkiwala started arguing. And this was a new constitution of judges. There were 6 new judges, and the government of the day believed that these 6 new judges will power the majority, because you need only 1 out of the remaining 7. So Palkiwala kept on receiving rapid fire questions. At the end of the day, he was not able to make a single point, because he would start, there'd be a question. So the Bombay Bar, because they actually, M.K. Nambiar was asked to argue, he's I'm too old, go to none. So Palkiwala said, this is not going to work because they're not letting me argue. That is an experience all good lawyers have had at some point or the other before a bench, which feels very strongly on a subject. So when you argue, you'll either say, yes, yes, we know that, next point, please. Or some question making it clear that you're not getting anywhere. So they went to the Attorney General, the great Chandu Daftari, and said, Chandu bhai, it's not working. They're not allowing him to argue. I mean, it so happened the Chief Justice Sikri had called Chandu Daftari for a cup of tea. And he said, so how is, that was day 1, how is the matter going? He said, oh, fabulously. My niece has come from Oxford, and she says it's a fabulous court, great judges, and they're articulating themselves so well throughout the day. And there's this pesky man standing in the middle who keeps on interrupting them all the time. All the time. Said, all right, Chandu, I'll tell brother judges that we'll let him argue. That's why you wanted the tea, isn't it? No, I wanted to meet you. So the next day, the Chief Justice said that we will put our questions only at 3:30 p.m. So Palkiwala, you can argue till then uninterrupted. So that is how Keshwanand started. Now, Keshwanand is another very interesting story. If you read the judgment, I confess I have not, because it is several hundred pages, the whole volume of SCC. But I claim to have read it, like all good lawyers. It is actually 616. 6 judges, including Justices Palekar and Chandrachud, say that there is a limit on Constitution in the Constitution. Amended, because amendment by definition is no limit to it. 6 judges who are supporters of the Golaknath view said, of course there are inherent democratic limits, etc. Neither of these 12 use the word basic structure, subject to correction, because I've already given the caveat, I've not read it, but we did test it on a computer by saying basic structure, then got a blank in the 12 judgments. Basic structure is only mentioned in one judgment of Justice Khanna, who says that, of course, when you're dealing with amendment, it can't be such as to destroy the edifice of the original. That basic structure cannot be changed. Right? But there is no foundational approach saying there has to be a basic structure, this is how it has to go, which you would expect from the judgment which lays down the basics. So this was 616, which meant complete confusion. Now look at the counter majoritarian administrative skills of the Chief Justice Sikri. There was only one judicial conference, greatest and most important of Indian Supreme Court judges, where only those 6 plus 1 were invited. Other 6 were not invited. Justice Sikri was thereafter asked when he laid down office, Sikri, that why didn't you invite the others? No need for it, because they were not agreeing with this. When you have a judicial conference before a judgment, the whole idea is that maybe I'll persuade you, maybe you will persuade me, nothing. Then there was what is called the view of the majority, which was a note which was circulated after the 11 judgments were pronounced. Judgments are pronounced. Technically, once the judgments are pronounced, you're functus officio, right? Unless you exercise review. And that was note, the majority view. That note was called the majority view. And it went like this. Yes, brother. Yes, brother. There were no lady judges there. 9 people signed that. Proposition number 2 was there is a basic structure of the Constitution which cannot be taken away by the amendment. This included Justices Palekar and Chandrachud, who had said there are no limit, Chandrachud Senior, of course, no limit to the power of constitutional amendment. But they signed this saying basic structure. Justice Khanna also signed it. Why? Because in Justice Khanna's judgment, point number 7, small Roman 7, as opposed to note numeral 2, was the expression that there is, of course, a basic structure because you can't, by an amendment, change the basic edifice or basic structure. So he said, yeah, that's my point. So you got 9 signing. The other 4 looked at it, each other, and said, sorry. So it becomes 9-0. So most of us only read the note, this particular note of the majority, which is 9-0, which is that there is basic structure. Now, this is neither majoritarian nor counter-majoritarian nor anti-majoritarian. This is a brilliant strategy of a Chief Justice who, despite the change in the judicial personnel, wanted to use this new theory of basic structure, which has, of course, been noticed in Golaknath, and giving us an enduring legacy because it was so important. And there was another little twist, which is always there, which you only see as a practicing lawyer, that like many, many of our distinguished judges, there's a very important task which the great Chief Justice Sikri, who's actually done the nation a great favor by bringing in basic structure, because otherwise you wouldn't have that, had a 1-month trip in US just before he retired, which was a must-do. So therefore, he goes a month, comes back a day later with 3 or 4 days to retire. 24th April, this is signed. The note of the majority is transferred, and there is no judicial conference on that note. The other 4 judges and one of the judges who signed it said later on, we didn't know about this note. So the chief got it typed and circulated it. So that was the coup, how we got the basic structure. Now, look at emergency. What happens in emergency? In emergency, and I'll come back to the hospitalization incident also of Keshwanand Bharti. It's not jurisprudential. It's certainly not medical jurisprudence, but it shows how judgments are crafted. Let me finish it here itself. So when it became clear that it's not going the way as some people wanted, that it will be the death knell of Golaknath and no more. That is, the right to amend is absolute, full stop, end of story. Then, whatever may have been the reason, everybody knew that the Chief Justice has to go for a month. So what happens? Well, if one judge falls ill, then how can he give the judgment? Very simple. So Justice Beg fell ill and he was hospitalized. Palkiwala and all stormed into the chamber of the Chief Justice and said, this can't be. Judicial review, no judicial review, counter-majoritarian, no counter-majoritarian. This can't be spirit of liberty, no spirit of liberty. How can this be? You drop him from the bench and make it 12. 12 can overrule 11 if need be. So the Chief Justice said, okay, I'll go and visit the judge. And he made it known that he will go and visit Justice Beg. And then God was kind, Justice Beg quickly recovered and came back. I'm sure we are all on the same page. So recoveries can be remarkable. This also happened. And the last thing is, of course, in the supersession, when Justice A.N. Ray, who was one of the four who had not signed it, superseded the others, the same wily Chandu Daftari was asked, how do you explain it? He said, very simple. The boy who wrote the best essay got the prize. Anyhow, now this is what happened in the basic structure judgment. Then you have emergency. All the high courts, by and large, all the high courts, except I think Delhi, took a view that Article 358 and 359. 358 says that the moment emergency is declared under 356, Article 19 gets suspended. Suspended animation. 359 says that once there is a proclamation of emergency, the President can, by an order, declare that the right to approach the court for enforcing fundamental right is also suspended. Part 3 rights, not fundamental. All Part 3 rights is also suspended. That declaration was given. That was challenged. In the interim, bails were given. So the matter comes up before the Supreme. Now it should have been very simple. There is a basic structure doctrine. This is clearly contrary to the basic structure doctrine because they are not said what all it contains, but surely it would contain 14, 19, 21 elements thereof. Can you imagine in ADM Jabalpur, none of the judges deal with basic structure. They are themselves who are authors who have created it by that famous note of majority. And this is only 3 years later, 73, 77, 4 years later. Even Justice Khanna, whose dissent is of course famous now, immortalized, puts it on some kind of natural rights, which was a theory debunked in Keshwanand. So the majority went along, did not exercise counter-majoritarianism. The Supreme Court did not exercise counter-majoritarianism, did not exercise anti-majoritarianism. It just went along, not because they were sure that the median of public opinion is in favor of non-interference, but as I said in the beginning, because of what I call the politically relevant public opinion, a strong center government, a strong party in power, and a strong parliament with a strong message that this is how we want to do it. So that is why Dorff in his article says that the real question today in the counter-majoritarian dialogue is, and this is what he says, quoting Barry Friedman, for all of history's frequent talk about independence of judiciary, that independence exists only at public sufferance. And the question is, not merely of counter-majoritarianism, but is the impulse strong enough to give benefit to the minority which needs it? And that's the question I'll leave you with, because that's the question that never goes away. That question remains and resurfaces in different forms in every society, and we are no exception. So that is how, while dealing with ADM Jabalpur, the court just ignored basic structure. The interesting part is there is also a jurisprudential reason for it. And the jurisprudential reason is that basic structure is really the question whether by an amendment you can change the basic structure of the Constitution. Right? ADM Jabalpur, there was no amendment. It was the existing Article 358 and 359. So can you say that basic structure can be used against the basic structure of the Constitution itself? Because 358 and 359 is a part of the original Constitution. It's not brought about by an amendment. So can you say, no, I will strike down a part of the original relying on basic structure? The court did not want to be counter-majoritarian enough, and suffice itself by saying that we have hope that it will be properly used. Now look at the way counter-majoritarianism has played out in the rights of gay people. So in 2009, July, comes the Nas Foundation case in the Delhi High Court. And I'll now close quickly. A bench of Justices Shah and Murlidhar, both of whom deserve to be in the Supreme Court, both of whom did not make it to the Supreme Court, which is, for both, I think it's a tragedy which we have to live up with, but so be it. They read down 377 to say that it only applies, like 376, which is the offense of rape, when it is non-consensual. In other words, there is nothing illegal about relationship between people of the same sex. But remember, the government of the day, 2009, vehemently opposed it. So the median of public opinion, if you treat it as represented by what the government has to say, was against. Yet the counter-majoritarianism was sufficient to read it down, which I thought was a very, very clever via media, and rightly so, because it pushed the dialogue further. Comes up to the Supreme Court in 2013, December. A bench by one of our very fine judges, Justice Singhvi and Justice Mukhopadhyay, and they reverse it by saying this is for the Parliament to decide. Again, the government comes very strongly and says this judgment is wrong. Right? Then comes the privacy case, Puttaswamy, in 2017, and the matter is revisited in Navtej Singh Johar. Now, in Navtej Singh Johar, what happens is, government comes and says, we have no view. Puttaswamy is there. And the churning which happened from 2009 to 2000 and Johar is September 18, moved the median of public opinion. The resistance to that idea changed, and people said, yeah, not my lifestyle, but somebody's lifestyle. Good luck, why not? Why? Because ultimately it is the spirit of liberty. That there's always a doubt. I believe in it, but I'm not too sure. Maybe that's a better way. I don't know. I don't think so. Clearly, no. But that is no reason to have 377. And the government withdrew. So the political support, as it were, to the idea went. And in Navtej Singh Johar, they restored the position of the Nas Foundation High Court judgment. But when it came to marriages amongst gay people, which is superior, the counter-majoritarianism was feebler, stopped at 2 judges, with 3 judges saying sorry. Though in America, of course, in 2015, you had permitted gay marriages. It stopped there. And even the 2 distinguished judges said that not marriage, but civil unions. So you see how the Dorff theory works in on counter-majoritarianism. It's not an extremely strong impulse that, come on, let me take the sword out and let's see what happens. No. You look at it, how is it going? Will the society accept it, not accept it? Do I go that far? Marriage? All right, civil union. The other side is no marriage, go by law. Let the legislature is there. If it is needed, they'll do it. So that is how this works out. For those of you who are interested, there's another Harvard professor called Michael Klarman who has written a very nice article called From the Closet to the Altar, when the American Supreme Court had upheld the right of marriage. Look at America. So you have the abortion debate, Roe versus Wade. A woman has a right to her own body. Only question is viability of the fetus, so 28 weeks. So this pushes the public frontier. That's not the median of public opinion. So as Barry Friedman says, yank them back. So they were yanked back. First, in the Planned Parenthood judgment, Pennsylvania. Now, the earlier one was the Warren Burger court. Then is the Rehnquist court. And then bring it down to 24 weeks. So you're paring it back. And then, of course, the Dobbs judgment with John Roberts' court, which overrules it. So counter-majoritarianism is one of the tools. How it is exercised is, and this is not, by no way does this mean a committed judiciary. That's a different debate. That's not the point I'm making. That's a wrong analogy. Because judges are human beings. They also look at the totality and say, no, this won't work. Then as a lawyer, you argue, you say, will this point work with this bench? With this bench, this point won't work. No point hammering it. Let's try the other one. So that is how they function too. Now there's another very interesting aspect, which is we all look at ADM Jabalpur as a great disaster of a judgment. I'm not so sure. Why am I not so sure? Look what happened after it. If ADM Jabalpur had granted the bail and struck it down, then the political process would have remained as it is, and probably the same party which brought in emergency would have continued. ADM Jabalpur said hands off. Right or wrong? It may still be a wrong judgment. I'm not making that point. But look at how the reverse Thayer doctrine works. So there were elections, and that party was thrown out. So for the first time, your political maturity as a nation increased. You moved away from a single party Congress, and you decided that, yes, you will try even with coalition. It is another thing that Congress came back again. But then you developed the further political learning of the society, which would have been lost. That doesn't make ADM Jabalpur right. But it's surely an input to be considered, that it worked itself out for the benefit. And then, of course, one last judgment. Incidentally, my father had written this. He was called to the US along with Fali Nariman. And this is what his view was, that look at this side of ADM Jabalpur. It helped the political wisdom to work itself out and the electorate to say that, look, we don't want you guys. If this is what you do, we don't want you. But of course, it presumes that there are elections. Because if there are no elections, then that's it. Professor Lawrence Tribe, who taught us constitutional law, and I'm sure my distinguished friend here as well, wrote on Maneka Gandhi. Now, Maneka Gandhi is a classic case of prima facie going counter-majoritarian, but really giving a relief more oriented to laying down the law. Because Maneka Gandhi came up with that 14, 19, 21, there are no separate silos, read as a whole. When Soli Sorabji, who was appearing for the then Janta government, said we are not opposing the passport. And Chandrachud writes that in his senior Justice Chandrachud writes that in his one-page agreement, saying, I agree with what Brother Bhagwati has held, but frankly, they had considered it. What else can a judge do? Very well. It's like by saying, well, I agree with what Professor Rajkumar says, but frankly, this issue doesn't survive because the government has said we'll give you the passport. There you are angling for that median of public opinion. Also, I think, and that is of course a subject matter of another discussion, after emergency, the Supreme Court faced an institutional crisis of credibility, that the High Court had upheld the rights of citizens. You guys came up with ADM Jabalpur. So there's that whole plethora of public interest litigation, do this, do that, various orders, all of them within the median of public opinion. Of course you should do that. Of course you can't have blinding of under trials. Of course under trials cannot be given such a long incarceration. Of course you must lay down your laws and have your public utilities, etc., etc. And Maneka Gandhi, in my view, has to be understood in that manner. So really to conclude, the counter-majoritarian exercise is, in my view, akin to the dissent of a judge, with the difference that a dissent is not binding. Counter-majoritarian exercise by a court would be binding, naturally, if it has the majority. Because a dissent looks at the brooding spirit of law and intelligence of a future day, that it will correct the error made. The counter-majoritarian instinct looks at the brooding spirit, but of society, so that they will move on a notch and move forward. So that is where you have a judge with a vision, like in the case of gay rights, saying that, look, this is the way to future. I know you may not agree with it now, but this is where you must go. Or Vishakha's judgment, sexual offenses or harassment at a workplace. So this is where counter-majoritarian comes in. I'll conclude with an Urdu couplet. I think amongst all the distinguished people you have had here, nobody would have either began or ended with a Urdu couplet, but I will do that, because that fits into my understanding of what is this counter-majoritarian exercise. Hoon garmiye nishaate tasavvur se nagma sanj, and I'll explain it also. I'll not leave it at that. Main andalibe gulshane na afrida hoon. Garmiye nishaate tasavvur. Garmi is passion. Nishaate tasavvur is imagination. Nagma Sanj is singing. So he says this nightingale is singing out of passion, of the imagination, of how things should be. That is what you are doing when you are either dissenting or going ahead and acting counter-majoritarian, striking down a law. Hoon garmiye nishaate tasavvur se nagma sanj. And who am I? Main andalibe gulshane na afrida. I am a nightingale of a gulshan, chaman, which is na afrida, which has not come into existence. So I sing out of passion for an idea for which the time has not yet come according to many, but I can see the light comes from there. Thank you very much.
Thank you so much, Farag, for that fascinating lecture, but also so many amazing snippets of information that many of us who have read and rereadings of the Keshwandabati judgment, but also many other things. So I really appreciate your lecture, both in terms of its depth, its breadth, its intellectually deep engagement. And so let's move into a Q&A session right away. So the floor is open. Feel free to ask questions, and let's, take a few questions and then request Parag to answer. Yeah.
Good afternoon, sir. So my question to you is that, you talked about
all of you for your active engagement and thoughtful participation. As we draw towards the conclusion of our program, I would like to invite Professor Debru Sridhar Patnaik, Registrar of OP Jindal Global University, who will deliver the concluding remarks, encapsulating our discussion and inspiring us their journey to knowledge.
Thank you very much, Asmita. First of all, on behalf of everyone present here in the university community, I must thank the Vice Chancellor to start with for having instituted these lectures, because when we have a memorial lecture, it's an opportunity for each one of us to know about these inspiring people and scholars and jurists and coming from different walks of life. Like today, we are having Dr. Granville Austin Memorial Lecture. So it's an opportunity for students and teachers and coming from different streams to know about his works, his legacy, and the seminal contributions he has made. And the movement became more worthwhile with the presence of Mr. Parag Tripathi, Senior Advocate, Supreme Court of India, for his lecture. It's so very insightful and with precision of thoughts, and it's become more enchanting with shafts of wit and humor, which is important inside a classroom or anywhere else to even make the complex more comprehensible. So we are grateful to you, Mr. Parag Tripathi, for your time this afternoon to be here with all of us. And we are indeed thankful to each one of you for your participation and for your contributions, and even to Professor Sudarshan for sharing his lived experiences and his engagements with Granville Austin. I hope that we will sincerely take inspiration not only from the talk, but even from the works of Granville Austin and continue with our studies and research. Because for students present here in particular, it would be worthwhile to examine even the method adopted by Granville Austin as part of his works, and even so many ideas were even enunciated by Mr. Parag Tripathi, which could go on to become part of your further reading, but even they could sort of become genesis for your papers and research assignments, so on and so forth. So it's a fulfilling moment. We are grateful to each and everyone for organizing this lecture and for this afternoon. Thank you so much. But before we disperse, I will request the Vice Chancellor to felicitate the guests this afternoon. Thank you so much. Please be seated.
Students, please give a big round of applause. Students, kindly remain seated till the dignitaries leave the auditorium. Thank you.
On a lighter note, I must say that we were able to get Parag here to campus because today the courts are not working. These are all unbillable hours of this extremely busy lawyer. So thank you so much, Parag, for being here.